Partners. I'm Manal Stambouli. I'm based in UNICEF New York with the Human Rights Unit. I'm here with my colleague Adam Jones, also working at UNICEF New York. It's a pleasure for me to open part 4 of our global webinar series on supporting independent human rights institutions to advance accountability for children's rights. As you may already know, this series has two main objectives. First is to facilitate the sharing of country-level experiences and promising practices of independent human rights institutions, or IHRIs, while also highlighting common challenges and identifying way forwards. Second is to promote and enrich cooperation and partnerships among these institutions, but also UNICEF country offices, UNICEF national committees, governments, and civil society in support of the work of these institutions. The webinars present and are guided by a series of tools for independent human rights institutions that were recently developed by the UNICEF Regional Office for Europe and Central Asia and partners. The tools aim to guide IHRIs on concrete steps that can be taken to strengthen their work with and for children. 3 tools have been developed to date and they are available online. They basically cover 3 themes. One is promotion and outreach with and for children, the child participation in the work of independent human rights institutions, and child-friendly complaint mechanisms. Today, our focus will be on child-friendly complaint mechanisms and will feature UNICEF and IHRI perspectives from Morocco and Uganda, as well as the UNICEF tool that was recently developed on child-friendly complaint mechanisms. The presentations will be followed by a Q&A session. So I think we are now ready to start. Our first speaker will be Vanessa Sedletsky. Vanessa is a child rights expert with over 15 years of experience. Her work has spanned a wide range of child rights issues with a focus on CRC implementation at the national and local level through law and policy reform, independent institutions, child-friendly services, as well as advocacy with UN bodies. She's the main author of Championing Children's Rights, a global study of independent human rights institutions for children. She has advised on the establishment or strengthening of independent human rights institutions in a number of countries. Thanks all for being here, and thank you, Vanessa. Over to you.
Thank you very much. I don't know if you've moved the slides, if I cannot see them, or yeah, okay, so perfect. So I'm very pleased to introduce you to this tool, which is part of the NHRI series for child-friendly mechanism, and this is a tool on child-friendly complaints mechanisms. The objective is to provide guidance to NHRI on how to establish and strengthen such mechanisms, to ensure that those complaint mechanisms are accessible to all children, including the most marginalized, to help NHRI in ensuring that complaint handling is done in a child-sensitive manner, and I'll get into what that involves, to identify the strengths and the challenges that NHRIs face in handling complaints in an effective manner for children. The tool is based on a number of practical and promising examples from the field, which I won't get into today because we have 2 very solid examples, and I think it's important that they have sufficient time to present their experiences. And finally, I'll give you some introduction of the framework we propose for monitoring and evaluating the child-friendliness of complaint mechanisms of NHRIs. Next. Why is a complaint mechanism so important for independent human rights institutions for children? First of all, because it is a means through which children who believe their rights have been violated can seek redress and make the violation stop. When we talk about children, the complaint mechanisms can be used by individual children on individual cases, but in many countries they have always also been used as a group of children filing a complaint. For instance, children living in a certain area and not having access to school, or children with specific circumstances, for instance, children with disabilities, having in common a certain challenge in having their rights respected. So the complaint mechanism is integral to a right to a remedy and to access to justice. And we know that the right to a remedy is part of the human rights framework. It's not as such explicitly recognized in the CRC, but the CRC committee has underlined that this is an important right for children as well as for adults, but for the Committee on the Rights of the Child, obviously focusing on children. And it is a way to make human rights effective, and that's why it is so critical. The complaint mechanism of these institutions is particularly important for vulnerable groups, and of course children are part of them, and including marginalized vulnerable children, and I'll get into this. But the complaint mechanism is also important for the NHRI itself, because it is a critical source of information on the experiences of children on a daily basis, on the kind of violations of their rights, the kind of violations they face, and it gives the NHRI a lot of inputs on the evolutions in society that may raise issues for children. It is also an important material for advocacy because it enables the NHRI to know which issues are particularly important and to propose policy reform in that respect. It also enables the NHRI to give evidence on the concrete difference it can make in children's lives, and individual cases often provide the kind of illustration that is needed. Next. There are a number of overarching principles that apply to child-friendly complaint mechanisms. I won't go into them into details because I think most of you are very familiar with the child rights framework, but it's important to underline that the reference framework for the complaint mechanism needs to be the Convention on the Rights of the Child. And in many instances at the national level, some pieces of legislation may not fully reflect the CRC provisions. But when handling a case, it is important that the NHRI takes the CRC as its basis. We know that children who come to the complaint mechanism are in a vulnerable situation. They have their rights violated. They might be at difficult times. And it's particularly important that their dignity be respected, that the issues they bring are not considered as trivial or not important, but are dealt with in a sensitive manner, that the children's views and voices are heard and respected. The principle of the best interest of the child needs to be central to complaint handling, both in terms of the process, but also in terms of the outcomes in light of other interests that may come into play in a specific case. The principle of the right of the child to be heard and the participation of children in the complaint handling process is very important. Children should be able to express their views on their situation, but also on the complaint mechanism in general. The principle of non-discrimination and in particular attention to the most marginalized and excluded children, the most vulnerable ones, is particularly important as those are the ones whose rights are most likely to be violated. And finally, the principle of protection is central as well, as children who come to the National Human Rights Institution might be at risk of harm or significant harm. So measures need to be taken to address the situation. But protection also involves addressing possible retaliation when the child denounces a situation, or preventing secondary victimization, for example. Next. So how do those principles translate into practice? There are a number of elements to take into account when considering a child-friendly complaint mechanisms. First is accessibility. Obviously, this is a central aspect of child friendliness. Children need to be aware of the mechanism. They need to know how to contact the human rights institution in case they have a difficult situation, and all that information needs to be made available to them in a way they can understand. Children need to be able to directly file a complaint. We know that in the judiciary, oftentimes children do not have the legal capacity to bring a case to court. For NHRI, it needs to be different, and children should be able to file a complaint without intermediary, without a legal representative, without going through their guardians, even if those are informed at a later stage or are brought into the picture, always in line with the best interests of the child. The NHRI also needs to remove possible barriers and identify them as well. Many barriers are common to all institutions and to all services in the country. But the NHRI has this advantage of being flexible, and so it should really take proactive steps to remove such obstacles. There might be attitudinal aspects, such as the way staff interacts with children or with certain group of children. The geographic accessibility is important in that if the NHRI is only located in the capital city, it should find ways to reach out to children and to people who are in remote locations or who are in other parts of the country. Physical accessibility is an essential dimension for children with disabilities, of course, but also for all children to have a space in which children feel comfortable. Communications need to be made in a child-friendly manner using accessible language that children can understand, but also other tools to communicate with children. We've seen all of this in relation to promotion and outreach as well, and I encourage you to look at that tool in addition to this one. Formalities need to be minimal, and any institution who comes to know of a situation should be able to take the case on its own, even if the child hasn't filed formally filed a complaint. And any economic barriers need to be addressed. Usually, and pretty much everywhere, this complaint mechanism is free, but we need to be mindful also of possible hidden costs, such as transportation costs and how to reach the institution and so on. The second important element is responsiveness. Responsiveness means for the NHRI informing the child and the families and the complainant that it is actually looking into the complaint. So it requires acknowledging receipt of the complaint, explaining which process will be followed, investigating the case or referring it to another institution, and in any case, keeping the child constantly informed. Time is also of the essence. We know that children's sense of time is very different from adults. If an institution receives a complaint about a child not being able to go to school because the director has refused to sign him or her up, if it takes 6 months to handle the complaints and to solve the issue, that's a full school year that is gone. And in on various areas, the development stage of the child means that complaints need to be handled swiftly. So depending on, oftentimes the law doesn't specify the length of time, the reasonable time for response. Tools that have been produced by various institutions often indicate that about 2 months is a reasonable time to give the opportunity to investigate the complaint, to respond to it. But we would encourage not to go longer and to have emergency procedures for some cases that might require urgent attention. Next. Fairness is a core principle of due process, and even though the NHRI isn't required to follow the same rules as the judiciary, it is still important that the complaint handling procedures be fair and impartial, that if they're any conflict of interest, they're addressed. And here again, we see we've underlined it in several webinars, but the importance of independence for the institution to guarantee this impartiality and fairness. There needs to be rules of procedures that set the process for complaint handling and that are communicated to complainants. Investigations need to be thorough, not just superficial. They need to include diverse perspectives to have a complete understanding of a situation. And complainants need to be informed of the possibility of referral or remedy if they're dissatisfied with the recommendations that are made. Information of the child is, of course, an essential element, and I've gone into this for various elements as it is cross-cutting. But it is particularly important for the child to be informed about the process, the status of the complaint, and also the outcome, even if the institution decides not to follow through a complaint for a set of reasons. The reasons why, the motivations need to be explained to the child, and silence cannot be the answer. Finally, the last critical element is privacy and confidentiality. And here again, the situation for the complaint mechanism doesn't differ much from the situation that's prevailing in any justice system or child protection system, in that there needs to be privacy provisions through a relevant policy. Professionals need to be bound by confidentiality rules and be sanctioned if they breach them. There should be a principle of non-disclosure of information that could lead to the identification of a child. And the media should also follow some regulatory provisions to not leak any information that could lead to the identification of the child or put the child at risk. Next. So how to strengthen and to set up and strengthen a child-friendly complaint mechanism? The first principle, which is, I must say, not often implemented, is to involve children in the design and in the review of the complaint mechanism, to ask children what they need to be able to access the complaint mechanism, what has been their experiences of filing a complaint, have they been satisfied with how it was handled, how it can be improved. And so children who have been through the process can provide very relevant information in this respect. Staff need to be trained on child-friendly complaint handling and how to interact with children. What are the differences between a complaint related to children that involve children and complaints that involve adults? Partnerships with other public institutions, civil society organizations are very important, because the NHRI will often have a very small team of people, very limited resources. And so by partnering with others, it can reach out to much more children, make the complaint mechanism known, but also access a different set of competencies in case very difficult, complex cases that may require specific knowledge. And obviously, keeping in mind the need for privacy and confidentiality, but it can reach out to others who have that knowledge. If the institution has a broad-based mandate, there is an absolute need for specialized staff to deal with child-related complaints. And this is a point that the practitioners, the institutions that have accompanied us in the development of the tools have emphasized. There needs to be a special department or a special team dedicated to handling child-related complaints with staff that are specifically trained. It is, as I mentioned in the introduction, complaints provide a lot of information, very relevant information for the NHRI, but for that, there needs to be a process to learn from those complaints by collecting, analyzing, and using complaint data. And I'll get back to this in terms of monitoring and evaluation. What are the key challenges that institutions may face and how to address them? The first one, obviously, is how to handle a large amount of complaints, which is also a sign of success, but can be very difficult for institutions with a very small team. one aspect, one strategy is to prevent complaints from accumulating too much by communicating about the mandate of the institutions. Oftentimes, institutions that are receiving huge amounts of complaints are also those that receive complaints that are unrelated to their mandate. So it's important to communicate about the mandate. It's also important to have referral mechanisms, memorandums of understanding with different institutions to be able to transfer a case to refer a case to another institution that might be more appropriate to handle it. And in any case, a large amount of complaints shouldn't prevent the institution from informing the child of where the complaint is and its status. Accessing the most marginalized children and children in general can be a significant challenge. And again, this has been addressed in the promotion and an outreach tool, but it's very important for the NHRI to keep in mind that there needs to be different strategies for accessing children by going to them as opposed to waiting for them to come to the institution. Acting swiftly, as mentioned before, is an essential element, and really the difficulty is again to handle huge amounts of work, but again relying on partnerships and being able to contact relevant institutions and having an internal system that enables to prioritize some cases is particularly important. And finally, a major weakness, but it's also an opportunity, I must say, for NHRIs is that they issue non-binding decisions. And so the institutions to which recommendations are addressed are not obliged to abide by them, which is why also the complaint mechanism is more flexible than the judiciary, for instance. Now, how to promote compliance? There are several tools: by following up with institutions, by calling them again and again, but this can be very time-consuming. Many institutions use annual reports to denounce lack of follow-up on their recommendations by various institutions. In some cases, the institution can also call on the media, organize press conferences or media events when some situations need to be addressed urgently. So there are a lot of tools for pressure surrounding the NHRI that can compensate for this lack of legally binding power. Next. Finally, how to monitor and evaluate the complaint mechanism. In the tool, we propose a basic framework, which can be, of course, expanded based on the mandate of each institution, and it raises three main questions. One is, how accessible is the complaint mechanism to children? And here, we encourage independent institutions to use complaint data to see who's filing complaints, but also who is not filing a complaint. The age, the gender, the nature of the complainant, the geographic origin, and so on. All of this provides a wealth of information. How effective is the complaint mechanism at handling complaints in a child-friendly manner? So here we refer to how the complaint is being handled. So, for instance, how many complaints have been handled during the year? With which results? What is the length of time for handling a complaint, median, average? Have children been satisfied, or complainants been satisfied with the solutions offered, and so on? And finally, what are the outcomes of the complaint mechanism? And here we think more at the macro level. Have there been any policy change prompted by the complaint mechanism of a series of complaints that have been put to the attention of policymakers? What does the complaint data say about trends in society, in policies? Have there been any legislative reform associated with complaints raised? So all of these provides the monitoring and evaluation framework at different levels, and that's really the idea of this complaint mechanism, is to be able to act to bridge the individual level of children's experiences with the policy macro level. So I thank you, and I encourage you, of course, to look at the tool for more details. Thank you.
Thank you very much, Vanessa, for your presentation, for unpacking what child-friendly mechanisms mean in terms of guiding principles, key components, also for giving some tips and advices based on lessons learned on setting up these mechanisms and on addressing the main challenges. And also thank you for sharing some monitoring and evaluation considerations. So now I will hand over the floor to our colleagues and partners in Uganda. Ms. Alan Nakalo from UNICEF Uganda Country Office, and Ms. Ruth Sekindi, who is the Director of Monitoring and Inspections at the Uganda Human Rights Commission. So thank you for being with us. The floor is yours.
Thank you, Manel. Can everybody hear me? I hope so. My name is Alan Nakalo. I work with social policy and advocacy in UNICEF Uganda. This afternoon, I would like to introduce, it's my pleasure to introduce Ms. Ruth Sekindi, who is the Director of Monitoring and Inspections at the Human Rights Commission. Ruth has been has worked as a human rights defender for over 13 years. And in her previous position, she has worked as the Director of Complaints and Investigations and Legal Services. She is very instrumental as being an advocate for child rights and human rights in Uganda. And some of the work we've done with the Commission that has been under her leadership is the CRC assessment report, which we did last year, which looked at the compatibility of the Ugandan legislations against the UN CRC, which work has provided a foundation for most of the work we are doing on child rights governance. So Ruth, over to you on giving the perspectives of Uganda in terms of child-friendly complaints mechanisms.
Thank you, Alan. Can everyone hear me? I hope so. My name is Ruth Sekindi, and like Alan introduced me, I work with the Uganda Human Rights Commission. Today I'll give a perspective of IHRIs complaints mechanism and how we ensure child-friendly complaints handling. I'll start with the mandate of the Commission that I'll briefly state, and thereafter I shall go into the details of how we handle child-related complaints. Now, the Uganda Human Rights Commission is a national human rights institution that is established by Constitution. It is the NHRI, or National Human Rights Institution, that monitors government's compliance and looks at and advises the state on how to handle human rights cases. It is charged with education and sensitization of human rights in the country. It is charged with receiving and investigating complaints of human rights related complaints. The Commission is also has a tribunal that hears cases related to human rights and makes sure that victims get adequate remedy. Now, with all that mandate of complaints handling, monitoring mechanisms, education and sensitization, reviewing of bills and advising Parliament and the state, the Commission was given powers by the Constitution, and those include powers to summon persons on any matter that they're investigating, powers to order for the production of any document relating to any matter that is being investigated, powers to investigate, and also order for powers to order for contempt of its orders, and it also has powers to order for compensation, production of people before its tribunal, or any other legal remedy. Can I go to the next slide? When you look at the Commission's mandates, we work very closely with all organs of government, including the judiciary, the executive, the legislature, and civil society. So in our performance of our mandate, we are at the heart of government's work, because then when it comes to the executive, we're supposed to advise and make recommendations to government, that is the executive. We monitor how the executive implements and performs or addresses human rights issues. When it comes to Parliament, we review all the bills before Parliament to ensure that they're human rights compliant. We also report to Parliament on our findings regarding the state of human rights in the country. And with the judiciary, we work as amicus curiae, though that's friends of court. And then we also refer cases that we can't handle to the judiciary. And then with civil society, we cooperate with civil society, we consult them, and we work very closely with civil society. Next slide, please. Now, just to take us through the receiving of complaints and how it is done, any person can lodge a complaint before our commission. Now, we currently have 23 offices in the country, and anyone can walk through our offices and report a case. So cases are reported through walking into our offices where someone lodges a complaint. People can send letters, they can send fax, they can send email. We have free phone, toll-free lines. We have various mechanisms, Twitter accounts, where people can lodge complaints. However, other than that, we have community barazas, and also we have a referral system. Now, through these, we believe that children, if they can't walk into our offices, they can write a letter and drop it in our offices. They can send an email for those who can access it. They can use our toll-free lines to call us in the event that they feel that they're in trouble or they want to tell us anything. Sometimes they come to our barazas. Community barazas are these meetings where we go to villages, we go to schools, we go down to the communities, we go to marketplaces, and huge crowds of people come to us and they talk to our staff, and that way we receive a number of complaints. So we create a forum where everyone can access our services. Now, most of the people who come to us are indigent, they're poor people, or even middle income earners who feel that sometimes they can't afford litigation in courts of law, they can't afford a lawyer. They're the people who mainly walk into our offices because all our services are free. So no fees are charged during lodging the complaint, during investigation, or during the tribunal hearings. All our services are free, and the commission attends to all people who contact the institution through the various mechanisms. Next slide, please. So so just to take us through the various stages of our complaints mechanisms, when a complaint is received, it is either registered or referred. Now, the complaints that are registered are the ones that deal with human rights issues. Unfortunately or fortunately, doors are open, so we receive so many cases, whether it's through walk-ins or letters or fax or emails. So through that, we have to sieve and determine which one is a human rights case and which one is not. Now, for those who walk in or those who write to us, or we send a communication, an email, to let them know that we have received their cases, and sometimes we require additional information to verify their cases. And many cases that don't have human rights aspects, we refer them to adequate, appropriate institutions. Now, some people just need legal advice, and so they walk into our offices and say, I have a land dispute, what should I do? So sometimes it's just legal advice, and they go home. Sometimes some people just want someone to talk to, and they go home. But where we feel that there is a violation, a human rights violation, we register that complaint. Now, for all the cases that are registered, we divide those that are investigated and those that are mediated. Now, for most of the cases regarding children, if they're not criminal in nature and they require, for example, child maintenance, where parents have to provide for their children, most of those cases are mediated because we have to expedite them in a timely manner. So children cannot wait to be fed, they cannot wait to go to school, they cannot wait to be clothed, to be sheltered. So most of those cases are mediated, as expeditiously as can be. Now, where it is cases of torture and other cases that can't be mediated, then those ones are investigated. And for those that are investigated, they end up in the tribunal, or sometimes the parties may require for a mediation after the investigation. So we know that most of the cases relating to child matters or children's matters are mediated because of the urgency that they quite often require. And quite often, in order to protect the child, most of these cases, the mothers or who are the biggest complainants end up preferring mediation and not litigation. Next slide, please. Just to give us a brief into the cases that we handled in 2017. In the year 2017, the Commission registered 746 complaints, and all these had human rights violations regarding to those complaints. And out of these, 508 were reported by women, and 238 were for women. 508 were for men, and 238 were for women. Now, majority of the cases that were reported by women related to children's rights. So we note that majority, women, mothers and guardians usually report cases regarding their children where fathers are not paying school fees, they're not feeding families, they have abandoned them, and they cannot afford rent. So we note that for the children who complain on their own and not through their parents, we note that the age of reporting is between 17 years, and majority are between 14 and 17 years, and it's a total of 2% of all our total complaints that we receive. This is often attributed to the fact that children rarely report cases on their own. So like I have said, most times mothers particularly are the ones who report the cases on behalf of their children, and that's what happens. So in view of this, we use we have a user-friendly mechanism to address children's rights. So the IHRIs complaint system is quite child-friendly, where we give feedback for all the complaints that are lodged to every person who lodges a complaint. This provides a clear delegation and procedures where we explain to the parties the processes that are going to be used. And then we also make sure that we prioritize the children's cases, so that because, like I said, their cases can't wait. They relate to education, health, food, shelter, and quite often there is an urgency about these violations. So the complaints received are handled in a child-friendly manner, where the children's views are always heard, and it's a requirement for all our staff to take into consideration children's views. And decisions that are made are always made in the best interest of the child. So children are often interviewed in many of these cases, and they have to be interviewed in the presence of a parent or guardian or any adult who the child is comfortable with. The staff are also required to be sensitive to the children's age, because we know that the level of maturity during interview is important, and it determines how the child answers, and that is very important when we're interviewing. The staff are also required to use simple and easy to understand languages when they're communicating. So we ensure that they don't use hard words, and it has to be in a language that they understand. Child participation is also encouraged, and here we say that children have a say on what they want, especially in custody cases. Children have a say to determine whether they want to stay with their father or their mother, and they have a say because they have different preferences. So their participation is always encouraged. And in all complaints that come through us, investigations are done in different ways. Quite often we visit the sites or the place where the violation occurred or where the matter of contention is. We often collect documentary evidence as much as we can. We often interview all the parties, including the victims, the witnesses, the perpetrators. We also bring on board experts who can help analyze these issues and give their expert assessments. And then we also collect physical evidence where it's necessary, just to build on our cases to make sure that it is watertight and it's not thrown out during the court hearing or the tribunal. So through all this, through the investigative process, we provide regular feedbacks to the parties who have reported, and we also have internal rules and procedures of the complaints processes that we communicate through the process to our clients, so that they know what we're doing. It's also a requirement that confidentiality and privacy of our complainants and witnesses and victims is recognized, because we don't want to put them into trouble, because we know that there could be reprisals. So issues of confidentiality and privacy are very important and key during the handling of cases, especially children. Now, we note that sometimes if you bring out information, especially against parents or teachers, these children may face reprisals. So many times we take into consideration privacy and confidentiality of the information we receive. All Uganda Human Rights Commission staff that are dealing with the complaints are required to swear an oath of secrecy. So that is one of the requirements for all our staff. That way we ensure that no information is devoured or sent out to people who shouldn't receive it. So in order to prevent reprisals, the IHRC also has strict rules of confidentiality, where we restrict our staff against disclosure of any information and that is in their possession, because this can lead to reprisals. And the staff also trained on how to conduct effective investigations, and this includes questioning techniques, investigative techniques, how to deal with difficult witnesses, how to deal with vulnerable groups such as children and other minorities. It is a requirement. Now, the staff also who deal with complaints are also trained on the principles and approaches on how to work with children when they're handling their complaints. For example, we teach them on how the tone of voice to use when they are dealing with children, because we have to address issues of power dynamics. Which pitch of voice should you have when you're dealing with the child, so that it's not intimidating. We teach them and train them on how to minimize differences and ensure non-discrimination. They are taught on attentive listening or listening skills, to look at the child, to nod their head, so that they know that the child does not lose focus. We teach them on body language and different aspects, not fidgeting, how to dress when you're interviewing child. We teach them on how to make sure that the room where they're interviewing is child-friendly. It should have toys. They should make children as comfortable as possible. We treat them about paying attention, keeping eye contact, questioning skills. Do you use leading questions, open-ended questions? Because children answer differently, and the way they answer, the way they respond, front to them could mean back, and back means front. And when they say yesterday, they could mean today or an hour that has passed. So we teach them on how to deal with communication between children and what children mean when they say certain things. And so that they don't misinterpret what children say. We also teach them about addressing power dynamics, so that children are not intimidated when they're in their presence. So most of the cases involving children's rights relate to the failure of fathers to provide for child maintenance and deprivation of the right to education, like I said. So in order to ensure that children are protected against getting involved between warring parents, the Commission limits the involvement of children in these disputes, even though we always ensure that we hear the child and hear out what they would prefer. So we put children out of harm's way by not making them testify against their parents, so that we avoid finding them in between the warring parents. So the matter is often left between the parents and adults to discuss and solve their relationships, so that we can save the relationship between the parents and their children. That way, because we realize that when children testify against their fathers or mothers, there's that bitterness between the parents, and there's resentment of parents towards their children. So we try to make sure that we don't put the children in harm's way, and where it is where it's possible, we let the parents solve these issues, but we put across the interest of the children. So the views of the children are always taken into consideration. So we also perform other activities to ensure that we sensitize and create awareness about children's rights. So the UHRC has developed various child-friendly books and IEC materials, such as the human rights and primary readers. We have small booklets that children read in school, from level 1, primary 1, or to primary 7, and then from primary 7 to senior 4. And we also have developed many posters, and these are distributed in schools. We lobbied, and human rights is part of the school curricula. And these books and posters or education materials are often used by also the children's human rights clubs in various schools. The Commission has also established a mobile complaints mechanism where the staff moves from one district to another, from village to village, sensitizing people on their rights. Some of these are called road shows, because we have vans where we park in a particular area, and then we make, we show videos, and then sometimes we have plays, so that communities around that area can come and listen in and watch and learn. So I've talked about the school clubs. So in a bid to inculcate the culture of respect of human rights and protection and promotion of human rights among the youth, the Commission has established human rights clubs in over 65 schools around the country. And through these, children are able to be proud of protection and promotion of human rights. They learn about human rights. They teach other children about human rights based on what they have learned. They do debates. They write poetry. They do artwork, all in a bid to promote human rights. We have also come up with school training materials, which is used by students. And the picture there shows the students talking to other students about human rights. That is a road show. We do road shows where we reach out to communities and we talk to them about human rights, and they also discuss on what they see and what they think is best for them with regard to the issues, the human rights issues affecting their communities. That is a way of reaching children and their parents. We also are required to advise governments on human rights issues. We conduct community barazas, and we also do media outreaches on television and radio. Next slide, please. So that is a picture of participants watching a drama show during a community baraza by the Uganda Human Rights Commission. So before I finalize, I want to talk about the tribunal. We have a tribunal where cases are heard, including children's cases, if they are not mediated. Now, this tribunal is user-friendly. It does not dwell much on legal technicalities, and these are reduced to the barest minimum. And the tribunal is a way of providing a remedy to victims of human rights violations. And that one has worked so well because majority of the victims are often compensated and they receive adequate redress. Finally, in conclusion, the complainants who contact the Commission are usually vulnerable persons. They're indigent, they're desperate. They're often people who need special consideration and protection to enable them take on usually powerful violators of human rights. This is therefore a daily struggle and commitment to make a difference in every person's life as we handle the numerous complaints that are lodged with us on a daily basis. So to us, every child, woman, and man deserves to live in dignity and have their rights respected and protected. Thank you for listening to me.
Thank you very much, Ruth and Alan, for sharing the solid experience of the Uganda Human Rights Commission and for describing so comprehensively the complaint handling process in the Commission. So thank you again very much for this. And I saw that it triggered a number of questions. So hopefully we'll, when we reach out to the Q&A session, we can address most of the questions. Now I will give the floor to our colleagues and partners in Morocco, Malika Al-Latifi from UNICEF Morocco Country Office, and Khalid Hanafiou, Head of the Child Protection at the National Council for Human Rights in Morocco. Thank you for being with us, and over to you both.
Hi, everybody. I'm very happy to be with you during this webinar to share with you the experience of Morocco. I am Malika Al-Latifi, the Child Protection Specialist in UNICEF Morocco, and with me Mr. Khalid Hanafiou, who is the Child Protection Officer in the CNDH. We prepare a joint presentation due to some concern regarding the language. Khalid Hanafiou will intervene to complete the. I'm happy to translate. The Conseil National des Droits de l'Homme, CNDH, is the national independent human rights institution, which is seen actually as an indicator of the democratic transition in Morocco, initiated in 1999. The creation of this institution came in a transition period when Morocco embarked in a process of promoting and protecting human rights in general. The institution operates since 2002 in conformity with the Paris Principle and has a broader mandate at both national and regional level, as it is encompasses 13 national committees. The main role of the institution is to protect and to promote human rights, but more concretely, the CNDH play a key role in human rights violation monitoring and reporting. Also, in terms of implementing of mechanisms that protect rights, the institution mandate allow the institution and its operational staff to visit places of detention, prison, and child protection center. The Council also, based on its mandate, has a responsibility to advise and provide support to the Parliament and government in the field of harmonization of the legislation and adoption of policy reform. UNICEF work with the CNDH since 2009. The main area of collaboration between the two institutions are the development of a training program on child rights reporting and monitoring in terms of support to the Human Rights Institution for the training Center for Human Rights, which is connected to the CNDH. The establishment of the independent mechanism for children rights, which was a great job and great work we undertook since 2009, and we have the chance to work with Vanessa Sedletsky in terms of the global study, and we use also the recommendation of the study to work closely with the CNDH to create to establish the independent mechanism for children. Also, UNICEF worked with the CNDH to follow up the implementation of the CRC, concluding recommendation and observation. Within this broad mandate, the CNDH I am talking about before 2018, has a broad mandate that limited his focus on category right till 2009, when in terms of our collaboration, as I have just mentioned, CNDH create, with the support of UNICEF, the post of the Child Protection Officer, which became Child Protection Unit. This unit worked on reception of child complaint, collect information on complaint, and refer to appropriate solution. In 2016, this position has been generated with the creation of the same unit and the appointment of a Child Protection Officer within the 13 regional commission. Actually, the CNDH is ongoing. Sorry. So I will talk now about the management of complaint of children. At national level, the CNDH received complaint from children since 2011. This was through the establishment of a special unit for children, as I have just mentioned. However, since May 2016, the process of receiving complaints has been strengthened following the appointment of child rights focal point at subnational level. Training program has also been tailored for the focal point and been implemented with UNICEF support as a concrete output of supporting the Training Center of Human Rights. The CNDH receive annually since 2016 100 complaints per year. Other complaint, this is the 100 complaint is what is examined and referred through its channel. Other complaints which have not really not fit with the mandate of the mechanism are referred to other stakeholders, including the institution of mediation. The CNDH receive, as I have just directly 100 complaints, and it is also on process to develop an IT application that will allow the possibility to receive and dealing with complaints from children who are connected. This IT application is ongoing development and will be operational as soon as the mechanism is installed with the official appointment of ombudsman. Next, please. So, concerning the responsiveness of the mechanism, CNDH has strengthened its strategic partnership with different actors to ensure effective treatment of children complaints that involve inter-area coordination work with actors and institutions concerned by child rights and protection at regional and level, and also at national level. At the regional level, the Commission took advantage of the organization of regional consultation with children, which took place on 2016 this consultation with children give possibility to work on concrete collaboration that include the mapping of stakeholders, collaboration with NGO. It is also, this dynamic at regional level has also reinforced the capacity of NGOs and coordination with NGOs to follow up of the recommendation of the CRC and concluding observation. Also, this collaboration has been mobilized to sort out the sort out the complaints and to report on violation based on a case management approach. All complaints are documented to ensure systematic follow-up with stakeholders of concern. I would like also to talk about a bit best practice that CNDH has experienced during its working with children, and that concern the work on outreach, awareness raising, and child participation. Within the CNDH new strategy include output related to protection of the right of children with specific focus on the principle of participation. The issue, this participation has been considered as a key intervention strategy focusing on the opinion of children, listening to their needs, and also to their recommendation. Within the strategy, children has been given opportunity to give their opinion on programmatic and ethical principle, as well as at level of the work of monitoring, as at a level of the treatment of complaints. The CNDH is in a phase. Would you please go back to the the taking into account the opinion of children is a programmatic and ethical principle, as I have mentioned, in the work of CNDH, and the CNDH in the phase of change with the establishment of recourse mechanism for children victims of violence of their rights. Working through their focal point to best communicate with children and have their point of view. I would like also to mention in this regard the work we done in terms of supporting a training program on monitoring and reporting on children's rights, where the focal point and also the operational staff of CNDH has been trained on listening of children and also on some operational way to document and to work on case management of violation. I concerning also this participation, or the key experience we have succeeded in participation was when the CNDH organized 13 regional consultation and the national consultation in 2016-2017. The consultation involved more than 400 children from different regions of Morocco and representing various profiles, including children in contact with the law. The children works mainly 13 weeks to analyze the gaps in terms of rights to education, to health, to protection, participation, and they deeply examined the the realization of this right from their own perspective. The children also consolidate a report of this consultation with a statement which was shared with key ministries and the parliament. The issue of participation has raised the issue of accessibility of the mechanism, which was largely debated during this regional consultation and the children proposal regarding the accessibility was taken in the account while preparing the new strategy of the CNDH. Also, all recommendation has been also translated to the elaboration of a plan of communication and also the IT application to collect a complaint. What we has learned from all this work we have developed through the process of establishment the mechanism for child complaint. Generally, it's a long-term process that requires implication of different stakeholders, not only CNDH but also NGOs and also Parliament. The process of adopting the law took much time because the CNDH has to manage political position and positioning and also constraint imposed by the context. Political engagement also is essential to in the area of establishing the institution. Bearing in mind that since 2009 till now, the work on the process has been impacted by the color of government and the political party. The concept of monitoring and reporting and its operationalization also in regard to child right violation is impacted not only by the capacity of CNDH to report and to manage and to deal with the complaint, but also it is impacted by the national system of child protection and the national system to respect to the rights of children in general. So it is essential to consolidate the collaboration and the coordination with different stakeholders involved in the respective. Investment in human resource also is a key because based on this experience, investment in training and building capacity of people who are in contact with the kids, who receive kids, who listen to them and collect all data about their violation, and who are also the intermediate between children, family, and the other stakeholders involved in the risk. So training is a must, and also exposition to international experience and expertise is very crucial for to carry on smoothly their work. Coordination and partnership at different level, including the local level, where the issue of resolving problems and responding and find appropriate way to respond to complaint is needed. So in general, we start from just to recap my presentation in few words. So we start by an institution with a board mandate which is not concerned by children's rights concretely and directly, to have now an institution that embraces special units for child rights, and in the process of appointing an ombudsman for children, which will deal with all issues on receiving complaints and addressing them. Thank you. I will give the floor to Khalid to complete the presentation if needed, and I am happy to translate.
Merci beaucoup. I'm sorry, my English is not very good. En fait, pour le CNDH, il y a un volet qui est très important, c'est la coordination et le travail avec le comité de droits de l'enfant. On assiste à l'ensemble des rencontres organisées par le comité de droits de l'enfant. On essaye de maintenir une relation durable, de partenariat durable avec le comité de droits de l'enfant, aussi bien au niveau de traitement et de l'analyse du rapport périodique qu'au niveau de l'élaboration des observations finales. Nous avons participé à l'élaboration de 3 observations générales ces dernières années et je trouve que cet exercice est très intéressant dans la mesure où il nous permet de procéder à des échanges d'expériences, de bonnes pratiques avec les autres INDH au niveau régional et au niveau international d'une part, et d'autre part, de voir avec le comité de droits de l'enfant tout ce qui est procédure en matière de gestion des plaintes, étant donné qu'avec le 3e protocole maintenant, le comité de droits de l'enfant aussi traite des plaintes des enfants et ils ont aussi un matériel. Et...
Can I translate? So the CNDH is very by the coordination aspect around the right of children. The coordination is in the heart of the realization of the right of children. So they are maintaining a good relationship, particularly with the Child Right Committee. They are maintain this good relation with in terms of providing a report or also preparing a report to the convention. They also participate in the debate of the committee and they participate in the elaboration of 3 observation general comment. They work with the committee, allow to the CNDH to collaborate with other India institution for human rights and get more insight about how to deal with the complaint and how to proceed in addressing the complaint.
Thank you very much, Khalid and Malika, for sharing the perspective and experience of Morocco. I think it would maybe be best because of the limited time we have now. We have about 15 minutes. So if you are fine with that, maybe we'll move to the Q&A session, and there will be an opportunity, hopefully, for Khalid and Malika to engage on some of the questions. So it's just being conscious of the limited time that's remaining that I'm proposing this way forward. Is that fine with you?
Yeah, okay.
Great, thank you very much. I will now give the floor to my colleague Adam Jones, who will be moderating this Q&A session, for which we'll have about 15 remaining minutes. Thank you, Adam. Over to you.
Thank you, Manel. Hello, everyone, and thanks to today's presenters for the great contributions. We'll start with the first question, which comes from Crystal Juralu in the Disabilities section at New York HQ. Crystal asks, are there examples of good practices in reaching the most vulnerable children, including children with disabilities? And related to this, are there examples of IHRIs collecting data on the number of complaints specifically from vulnerable children? So perhaps if we start with Vanessa for this question, please.
Yes, thank you. I was thinking I could address this one, and looking through the questions, there were a number of questions on reaching out to children that maybe we could take as a whole. I don't know, it's a suggestion. In terms of reaching out to vulnerable children, there are many institutions that have set up strategies to promote their work with them. So there, and I think it is Scotland, or yeah, it is in the UK anyway. They put up videos in sign languages, for instance, to reach out to children with hearing impairments. Many institutions have different tools to reach out to children with disabilities. And that includes also physical access and going where children with disabilities might be, such as some institutions where they might live or get an education. And so that's often an important area of work, although not always and certainly not enough. In relation to reaching out to children on the street, for instance, and other groups, various institutions have sort of mobile strategies, for instance, by having a bus that goes around to inform children about the existence of the institution. Now, I think it's important also to make clear that the complaint human rights institutions are, and I think colleagues from Uganda underlined that really well. They're a human rights mechanism and a monitoring mechanism. So it's quite different from
Vanessa? It looks as though Vanessa's line might have dropped there mid-sentence. If Vanessa comes back online, we'll return so that she can finish wrapping up. In the meantime, we'll go to perhaps if we go to the Morocco country office. Malika, did you have any thoughts to add on reaching the most vulnerable children?
For two things. For disabled children or children in disability, we have based on the data of CNDH, 5 complaints from children with disability that concern access to education and a case of sexual violence. The case of violence, the sexual violence, was referred to justice, and justice is now dealing with the issue. And concerning the complaint regarding access to education, the CNDH is on communication with Ministry of Education to reintegrate these children in schools. In regard to other vulnerability, as I have mentioned in my presentation, the CNDH has the responsibility to visit detention center and residential institution, and this visit allows the CNDH to get direct complaint for children who are in this center and institution. Over to you.
Want to add anything further?
Hi, can you hear me?
Yes, we can, Vanessa.
Okay.
Thank you.
Sorry. No, yes, I just, because I think it is quite important to differentiate between this monitoring and complaint mechanism that is offered by human rights institutions and the child protection system. So the first intervention would be if a child is in significant difficulties, and I saw there was a question also about possible harms and emergency measures. Usually a human rights institution will refer a child protection case to child protection services, but it's mainly if they don't act or if they're not able to act that the human rights institution would start working. They can also refer to the justice system in some cases, but its role is to monitor and to take on complaints mainly on the child protection mechanism. So I think that's important to underline. And then, of course, vulnerable groups of children are reached out through visits to places where they are mentioned children with disabilities, but that also involves children in care. And we have lots of examples from common law countries where there is a specific child protection mandate. And in which institutions, children's advocates go to those places. And so as they go to those places, they can collect complaints from children. I mean, again, it's always by going where children are that institutions can be known and accessible to them.
Thank you, Vanessa. We also had a number of questions in regards to the use of ICT. Maria Pia Bianchetti of UNICEF UK National Committee is asking if there's examples of institutions using forms of communication beyond sort of traditional platforms, so to speak. UNICEF Malaysia also asked a similar question. So if we go to Uganda, because they touched upon a number of examples, including engaging in community spaces and different technologies and SMS. So over to Alan in Uganda.
Hi, Adam. This is Alan, Uganda. Ruth had to step away because she had to catch a flight, but we're trying to connect Priscilla, who's her colleague at the Uganda Human Rights Commission, who'll answer some questions. Can I ask that you go on as we try to connect Priscilla?
Yeah, of course. Thanks, Alan. If we go to Vanessa and then to Morocco, if they have anything to add on the use of new technologies for supporting access to the complaint mechanisms.
Yeah, I think we heard some examples about Twitter, and many institutions have a Facebook account, for instance. So supposedly they can be reached through private messages as well, individual messages. I think what's really important is that these institutions be present where children are. So if children are present on Instagram, then they should be on Instagram. There is no limit to the use of new technologies. I mean, of course, in line with privacy requirements and safeguards, and that kind of safeguards, obviously. But many very active institutions are always trying to keep up with where children and adolescents are. And in relation to the different formats, oral, written, but the great tool for institution is the fact that they can take a case on their own. So the judiciary will need to have a formal complaint filed to take on a case. A judge cannot just decide to take on a case. IHRIs can. So with whatever means they're aware of a child rights violation or a problem, it could be in the media, not necessarily directly from a child, or it can be just a child's behavior when they visit an institution. They can take on a case, they can investigate a case. And I think that's their great strength. Thank you.
I would like also to talk about the IT application, which is developed by CNDH. This application is accessible for kids through tablet, computer, and telephone, and they could through this application send their complaint to the CNDH national and CNDH at regional level. This is the first, initiative to work on accessibility using new technology. It is not already operational because CNDH is waiting for the appointment of this new ombudsman, and also the member, as the CNDH is also appointing new member for the board.
Thank you, Malika. We'll try to fit in at least one more question, perhaps two. We had one from Sally Johnson in the new office of the Children's Commissioner in Jersey. Sally is asking if consent would always be sought from a child when someone is submitting a complaint on their behalf, and from which age would this commence? So we can go back to Malika for this. Malika, if you're happy to address that. And if Vanessa is on the line, I'm sure Vanessa will have some thoughts on that as well.
Yes, I think that's a very good question, because we often think of parents' consent rather than children's consent. And I think in all those cases, the main principle is that of the best interests of the child. So depending on the age, the maturity, and the type of case, and the reason why a child would need to consent or not, the consent of the child might be needed or not be needed. I must say I haven't seen pieces of legislation in which that consent is required. It doesn't mean it doesn't exist, but I'm not aware of any. Certainly consent of parents and so on is much more, there are many more rules on that. But again, typically in all rules that are in legislations for institutions, the strongest one are those that always provide for rules and exceptions based on the best interests of the child. So I think it would be for the institution to assess whether in a certain case they can proceed without children's consent or not, and it has to do with hearing the child's views.
Thank you, Vanessa. We think we're going to be a bit tight on time for a final question. So I think what we propose is that we address these questions after the session. We connect the speakers to today's participants, and we can continue the conversation in that way. I'll hand back over to my colleague Manel, who will speak about some future activities, and then we will be in contact later today to connect everyone in the session. Thank you.
Thank you very much, Adam. It was a very productive session. Unfortunately, too short to address the whole questions, but hopefully, as Adam mentioned, we'll continue and follow up today and tomorrow in the next few days. I would like to take that opportunity to thank really everyone, the speakers, and also all participants, for your active participation throughout this webinar, but also throughout the whole series so far. We are really willing to continue to build on child rights accountability work in partnership with all of you. We are hoping to pursue the webinar series with additional sessions this year, and we will keep you all informed about the next steps and way forward. We are hoping to have 2 or 3 more sessions in the course of the year. So thank you again very much, everyone, and we'll be sharing more resources and keeping you updated as we move forward. Thank you.